All right, ladies and gentlemen, we're going to get started. Good afternoon and welcome to everyone. Thank you so much for joining us today. I'm Caroline Spivak, and I will be your moderator for today's briefing. Please be advised that this briefing is being taped and recorded. Today's briefing will be an insightful technical discussion designed to explain the lengthy and complicated process that has resulted in last night's filing of the court-appointed mediator and monitor's plan of arrangement and compromise in the healthcare cost recovery actions. Many thanks to the lawyers who form the team representing a consortium of governments and territories who will be leading today's discussion. Our plan today is to hear explanatory remarks from each of our lawyers, after which we will open the floor to media questions. Media are invited to send questions to me by way of the chat, and we will endeavor to answer as many as possible throughout today's discussion. As a reminder, we do ask that you please identify your media outlet as you ask your questions. It's my pleasure now to introduce our first speaker, co-chair of the Class Actions Practice Group at Bennett Jones, and one of the co-counsel on this matter, Mr. Mike Eizenga. Welcome, Mike.
Thank you, Caroline. As Caroline indicated, we do act for a consortium of provinces. Those provinces are British Columbia, Saskatchewan, Manitoba, Nova Scotia, Prince Edward Island, and New Brunswick. And we also act for the territories of Nunavut, Yukon, and the Northwest Territories. I'm joined today with one of my co-counsel, senior partner at Siskins LLP. André has been our lead negotiator and counsel through these proceedings. And I'm joined by Preet Gill, managing partner at Bennett Jones Toronto office and an expert with respect to CCAA issues, which are central to an explanation of where we are heading at this point in the proceedings. By the way, CCAA refers to the Companies Creditors Arrangement Act, and we'll be referring to that regularly throughout. I'm also joined by Mike Peerless, head of the Class Actions Practice Group at Mackenzie Lake, and another co-counsel for our consortium of government clients. Each of us will have some brief introductory explanatory comments, and then Caroline will open the floor to questions. First, some background and perhaps an explanation of why we're speaking today. We have been under the constraints of a confidential mediation process for many years. But yesterday evening, the court-appointed mediator, the former Chief Justice of the Ontario Court of Appeal, Warren Winkler, KC, publicly filed a plan of compromise and arrangement, which is his plan to attempt to end the litigation. There remain some limits as to what we can say, given that many of the issues remain before the court, and we certainly can't disclose the content of mediation discussions. However, thousands of pages were filed last night, so we thought some explanation was required, particularly given that some significant inaccuracies appeared in some of the early media reports. Just to go to the history, the provincial healthcare cost recovery litigation has been ongoing in one form or another since 1997, when British Columbia passed legislation to facilitate litigation seeking to recover the increased costs to our healthcare system associated with treating smoking-related diseases. That has always been our client's aim, to deliver compensation and support to the provincial healthcare systems, to enhance their ability to provide healthcare for their citizens. And by the early 2010s, all provinces were pursuing similar litigation against key players in the industry. In addition, at this time, a very significant class action in Quebec was being pursued on behalf of individuals with smoking-related diseases. Their trial was successful. And in 2015, the Quebec class action plaintiffs obtained a multi-billion-dollar judgment in their favor. The tobacco companies appealed that decision. However, their appeal was dismissed on March 15, 2019. facing judgment in Quebec and the provincial healthcare cost recovery actions, several of which were moving toward trial. In the spring of 2019, the tobacco companies sought protection from their creditors and relief from the pending litigation by filing for CCAA protection. We'll hear more about the CCAA from Preet in a moment. At that time, the tobacco companies explicitly said that their goal was to achieve a global resolution of the claims and litigation they were facing in Canada. The court appointed the former Chief Justice of the Ontario Court of Appeal, Warren Winkler, to mediate the issues between the stakeholder litigants and the tobacco companies, as well as amongst the tobacco companies. Last year, the court directed that the court-appointed mediator prepare a plan of compromise and arrangement to attempt to bring the matter to a conclusion. And that plan is the plan that was filed by former Chief Justice Winkler yesterday evening. To be clear, this is not a settlement, nor is it a proposal by the tobacco companies. It is the result of the effort of the court-appointed mediator and the independent monitors of the tobacco companies to achieve a global resolution of these proceedings. And it is the outcome of a mediation process that began over 5 years ago and reflects the arrangement that the mediator has determined is fair and reasonable following his years of interactions with the companies and their creditors. And also, to be clear, all 9 of our provincial and territorial government clients endorse this plan and will be supporting it through the court approval process. So now, to take you through the key elements of the plan, I'll turn the floor over to André Michael.
Thank you. I will start with economics of the plan. The plan calls for a total payment of $32.5 billion. Over $24.7 billion will go to the provinces and territories for the benefit of the healthcare systems. Over $6.6 billion are for the benefit of individuals who have claims based on defined smoking-related diseases. This would include over $4.1 billion for the benefit of the Quebec class action plaintiffs, and over $2.5 billion for the benefit of other individuals across the country with eligible smoking-related claims. Another $1 billion would be paid into a national foundation to be established and chaired by healthcare specialist Dr. Robert Bell to provide ongoing support for cancer and other smoking-related research and treatment. If the plan is approved and implemented, approximately $12.5 billion would be paid upfront shortly after court implementation of the plan. We would hope this would happen in early 2025. This is money that has been withheld from the tobacco companies by the court during the CCAA proceedings. The upfront funds would be divided as follows. Approximately $6.3 billion will be distributed among the provinces and territories. Approximately $3.9 billion would be allocated for the Quebec class action plaintiffs. $1.75 billion would be paid into the fund to compensate other eligible individuals across the country who have been diagnosed with diseases which were held compensable by the Quebec courts. Also, $500 million would go into the National Foundation, with the other $500 million due the next year. In addition to the upfront payments. If the plan is approved and implemented, the tobacco companies will be required to make annual payments. In each of the first 5 years following plan implementation, they would be required to pay 85% of their net after-tax income. During the next 5 years, 80% of their net after-tax income would be payable. During the next 5 years, 75%, and after that 70%, until the total of $32.5 billion is reached. The estimate in the plan is that the majority, the global payment amount, will be paid within the first 5 years following court approval and planned implementation. A few other points are worth noting. If any of the funds designated to pay compensation to individuals, smoking-related diseases remain undistributed after the claims administration period, the funds will be paid to the government healthcare systems. The court-appointed monitors will become plan administrators under the supervision of the court, and throughout will continue to monitor tobacco companies' compliance with their obligations to the plan. If disputes develop, the matter in dispute can be brought back before the CCAA court. Finally, I will conclude by saying that the plan proposed by the court-appointed mediator and the court-appointed monitors of the tobacco companies addresses many needs. It pays compensation to healthcare systems that have been paying the costs of treating smoking-related diseases. Provides compensation for individuals who have legal claims based on diseases caused by smoking. As well, it provides funding for additional cancer, smoking-related research and treatment. We'll now ask Preet Gill to comment on the CCAA procedure.
Thank you, André, and good afternoon, everyone. First, I wanted to put the CCAA into context here. The CCAA is a federal statute under which companies facing financial pressure, including pressure because of lawsuits, as we saw in this case, can apply to court for a stay of proceedings, which grants them temporary relief from their creditors while they seek to reorganize or restructure within a court-supervised process. In 2019, these 3 tobacco companies each commenced proceedings under the CCAA. And as required in CCAA proceedings, 3 independent monitors were appointed by the court to act as its officer in each proceeding. Procedurally, while these are technically 3 distinct proceedings, they have practically been jointly administered. And as Mike noted, in April of 2019, the CCAA court appointed the Honorable Warren Winkler, KC, as an officer of the court to act as a mediator in these proceedings. And in 2023, Chief Justice Morowitz made an order under the CCAA expressly directing the court-appointed monitors and the mediator to develop the plans of arrangement and compromise within the existing structure of the mediation. And those plans are what were filed yesterday evening. If those plans are approved by claimants, approved by the court, and ultimately implemented, they will result in a global resolution of tobacco claims in Canada. Now, in the ordinary course, under the CCAA, the companies themselves would present a plan to be considered by their creditors and the court. But this is no ordinary proceeding, and the CCAA provides an immense amount of authority and discretion to the court to assist and facilitate a company's restructuring efforts under the CCAA. So in this case, given the large number of potential claimants, the multitude of interested parties, and the directions given by the CCAA court, the filing of the court-appointed mediator and monitor's plans of arrangement and compromise is a significant step in getting to a full resolution of these immensely complex proceedings. So now that those plans have been filed, what are the next steps? First, a hearing has been scheduled for October 31st, where the CCAA court will be asked to issue a claims procedure order and a meeting order. These orders are procedural in nature. They will establish how claimants will meet to vote on the plans and how they will be notified. If the court approves those procedural orders on October 31st, the date of the meetings will be December 12th, as proposed in the plans. And at those meetings, if the plans are approved by the requisite majorities of claimants, which is a requirement under the CCAA, they will then be presented to the court for approval. No date has yet been set by the court for its approval hearing. But when that hearing occurs, the court will consider whether the plans comply with the requirements in the CCAA and whether they are fair and reasonable and therefore should be approved. And if the court approves the plans at that hearing, the parties will then work towards implementation. So as I mentioned, the filing of these proposed plans and the scheduling of a hearing for the procedural orders is a significant step in coming to a resolution of these proceedings, but there are still more steps to go. Thank you, and I will now hand things over to our co-counsel, Mike Peerless.
Mike, you're on mute.
Let me end where Mike Eizenga began. This has been an incredibly long process, hotly contested each and every step of the way. We are now at a point where the court-appointed mediator has provided us with a plan for how to bring this process to a conclusion. The plan addresses many needs. It provides financial compensation to our strained national healthcare system. It provides financial compensation to individual smokers with claims against the tobacco companies arising from smoking-related diseases. It provides funding for a national, forward-looking foundation to expand research into cancer and other smoking-related diseases. We believe, and our clients believe, that the plan is fair and reasonable, and all of our clients will be supporting it through the court process that lies ahead. And finally, let me say this. If this $32.5 billion proposal is approved, it will provide clear accountability for the tobacco companies for past wrongful conduct and will return billions of dollars to our healthcare system for the benefit of Canadians.
Thank you, Mike, and thank you to Mike, André, and Preet for your remarks. We'll now open the floor to questions. Media are invited once again to simply type your question into the chat and we will put it before our speakers. In the meantime, we have our first question, and it asks, could you please provide a little background on why the funds allocated to Quebec victims seem to be significantly higher than those funds for victims in the rest of Canada and the differential in compensation? André, would you take this question, please?
The Quebec class action plaintiffs achieved a judgment in their proceedings, a judgment that was upheld by the Quebec Court of Appeal. The court appointed representative counsel for the claimants across the country because there did not exist class actions in all of the provinces throughout the country. So this was a method by which other claimants could receive compensation. And as I said before, this compensation would be providing benefits across the country, taking into consideration various legal requirements which have been outlined by the mediator and monitor within the plan of compromise and arrangement.
Anyone else like to add to that? Thank you, Andre. Our next question is, do all provinces support the plan? Perhaps, Mike, you might want to take this question.
Well, thank you for the question. The fact is, all of our provinces and territories support the plan, and we are certainly hopeful that the other provinces will, but they're not our clients. We anticipate that the sooner we can get everyone on side, the quicker we can get to a resolution and deliver benefits to healthcare systems across the country. But I really don't think I should speak for other provinces. I can tell you our 9 provincial and territorial government clients are certainly on board.
Thank you for that, Mike. Our next question is really, is there enough money? And perhaps, Andre, you might want to take this one as well. Does the settlement provide for enough money?
The criteria for the court to consider is whether the settlement, first of all, it's not a settlement, whether the proposed plan is fair and reasonable. All that this is a plan of compromise and arrangement that has been developed by the mediator and monitors as directed by Chief Justice Morowitz. The fact from an economic perspective is that the upfront payments are the funds that have been withheld during this court process, and almost all of the after-tax income of each of these companies designated under this plan to be paid to fund the $32.5 billion that is required. It is our position that the plan as developed by the court is workable.
Caroline, can I make one addition?
Please.
I think those of us who are litigators understand that particularly when we act for plaintiffs, and particularly in a huge case like this, it may seem that there's never enough money. This is a very significant, would be a very significant result, the largest of its kind in Canadian history, and $32.5 billion will have a huge impact, not only for people who have waited long enough to get their compensation, but also for our healthcare systems that, as Mike has indicated, are straining under the lack of resources. So the mediator and monitors have presented a plan that they believe is fair and reasonable as a way to end this litigation that has been going on for more than 2 decades, and we're supportive of it, and we think it is an excellent, realistic result.
Thank you, Mike. Our next question comes to us from the CBC, and we have, you said that the tentatively scheduled meeting for December 12th would require a majority of claimants to approve the plan. How exactly is a majority defined? And is a province just one vote weighted equally with one individual claimant who suffered smoking-related disease? And perhaps this question should go to Preet.
Yes, I will definitely start that. Under the CCAA, the majorities is what's often referred to as a double majority. So it's over 50% in number and 2/3 of the total value of claims. So you have to look, for example, if we take our clients, the provinces, the plan has set out and proposed the number of votes and also the proposed value of the claim. So both double majorities, or both majorities to make a double majority, have to be satisfied.
Thank you for that. We have a follow-on question, Andre, with respect to compensation. Can you elaborate on the actual difference in compensation per victim for someone who is resident in Quebec versus the rest of Canada?
Yes, of course, these are matters that are the subject of the Quebec class action proceedings, so they have their counsel. But from the plan, the payment for Quebec individuals would be up to a maximum of $100,000. And with respect to the pan-Canadian claimants, as I mentioned before, they have representative counsel who was appointed by the court. The plan calls for up to $60,000 to be provided for on a per individual basis, and the reasons for that are explained in some considerable detail within the plan, taking into consideration the various legal elements that had to be considered by the court-appointed mediator in making this proposal along with the monitors.
Thank you, Andre. Our next question goes to part of the tobacco company's responsibility. Does this plan of arrangement and compromise call for tobacco companies to admit their wrongdoing, and will there be some sort of public apology and acceptance of accountability from the tobacco companies? I'm not sure if Michael Peerless or Michael Eizenga would like to take this.
Well, I'd be happy to start with that. So, no, like most legal settlements, this doesn't include an apology or an admission of responsibility. As everyone has mentioned, it's not even a settlement yet. It's just a plan from the set forward by the court-appointed mediator and the monitors. And I don't want to make light of this, but in general, as counsel for plaintiffs, we prefer to get the maximum financial recovery we think we can get from a defendant, and assume that you can take seriously that this is an amount of money that shows that the companies have taken responsibility, whether or not they're going to say they take responsibility.
Thank you, Mike. Anyone else have any comments on that? Okay, thank you. Our next question is, what would happen to the companies, or what will happen after this plan is approved? And do they exit creditor protection and resume business as usual? Preet, would you provide input on that, please?
Absolutely. So the way the proposed plan would operate, it does contemplate the companies continuing an operation after, which is very typical in a CCAA proceeding. So if the plan is approved, there are then a number of steps towards implementation. But as I said, the plan that is being proposed by the mediator and monitors does contemplate them continuing in business.
And if I may just add to that, the plan also contemplates that there are reporting requirements by the companies to the court-appointed monitors, who then are becoming plan administrators. So they will continue to monitor under the plan of arrangement, the companies.
Caroline, one more comment, and that is, it's not quite business as usual, in that what's going to happen afterwards is that we will be taking 85% of their profits to fund these aspects of the program that has been proposed.
Thank you. We do have a follow-up just on your comments, Mike. Does that mean that then these companies will be rendered fully bankrupt coming out of this?
That's the answer to that is no, but it's more of a question for Preet, since it's a CCAA question. There are insolvency proceedings and bankruptcy proceedings, and this is a little different from a bankruptcy.
Yes, exactly. There's often a confusion. There's the Bankruptcy and Insolvency Act, which is made to deal more with actual bankruptcies. The tobacco companies are in the CCAA, the Companies Creditors Arrangement Act, and outcome of that proceeding is a plan of arrangement and compromise, as we have seen here. So it would not be a bankruptcy, But as Mike noted, it is not business as usual. While the tobacco companies will continue in business, what they can do is circumscribed by the plan if approved and implemented.
Thank you, Preet. And while we're with you, could you take the next question? And that is, what's the approval process for a plan of arrangement and how long does that take?
So the length of time depends on each proceeding. As we noted at this time, we don't have dates for all of the hearings. But if on October 31st, the court approves the procedural orders, the meeting of claimants to vote and approve on the plan will be December 12th. And we are working towards then a approval hearing for the court, hopefully in early 2025. After that, there are implementation steps in the plan that will need to be taken. While we cannot say definitively how long that will take, we are very committed to working towards a resolution as quickly and efficiently as possible.
Thank you for that. And just a rejoinder on the notion of majority approval, not quite fully understanding the definition of majority approval of the plan of arrangement. So the position is if 50% of the provinces representing 2/3 of the total value of claims approve, does that only result in approval of the compensation to the provinces? How do the votes of the individual claimants who suffered smoking-related diseases get counted? And is their portion of the plan agreed to separately? I know there's a couple of questions in there.
Yes, I'll try to explain. I didn't want to get too technical, but I will do my best to try to explain it. So what the claimants are voting on is the plan as a whole. So not just the, as you said, compensation element of it, but the entire plan. And so a majority in number of all claimants must approve the plan, so 50% above. Separately, you look at the value of everyone's claims. For known claimants, those values are proposed in the plan and were the result of the mediation process. There is going to be a process for that to be disputed, but those are the current valuations. And there will be a process again for other potential non-individual claimants to put forward claims. You then look at the total value of all claims and you get to the 2/3 of that number. And that's the way the double majority would work.
Thank you for that. We'll just wait and see if there's a follow-up to that question. But in the meantime, perhaps again, maybe this question is for Mike Peerless, and that is, so does this mean the litigation is over and concluded and the whole matter is settled now that we have a global approach to settling the proceedings?
Well, once the plan is fully implemented, assuming it's court approved and fully implemented, once that happens, and after certain post-implementation steps are taken, then yes, all litigation, tobacco-related litigation against these companies will be ended across the country for everyone, forever.
Great, thank you so much. When we speak of claimants, the question is how many individual claimants are counted, or do we have vis-a-vis provinces in the voting process, in the approval process? I'm not sure, Preet, if this question perhaps goes to you.
I will start and others can chime in. So there are class actions as claimants within the proceeding, and so they represent individual claimants with smoking-related diseases. So that is how individual claimants would be represented by a vote. The provinces are separate from the individual claimants.
Would anyone else like to comment on that further?
Well, this is, Caroline, thanks. And thanks, Preet, too, for being able to explain these CCAA issues in ways that we can't, or that I can't. But one of the ways in which there's obviously a difference between the claimants across the country that becomes hard to explain at an early stage here is that you have a class action in Quebec where there was a judgment on behalf of the people in the class. Across the country, we have potential claimants who may have claims against the tobacco companies, who also need to have the ability to have those claims looked at and administered. So there's a bit of uncertainty about that, but as Preet has, I think, emphasized, when you consider the issues related to a double majority and getting approval of the creditors, you do have to include everyone in that calculation, provinces and individuals.
Thank you for that. This next question goes to André. If the plan is approved, sorry, just a little technical. If the plan is approved, what's the time frame over which the future payouts would be spread?
The future payouts are to be paid annually, and the plan has contemplated that the payments would be in those 5-year increments, so in each year of those 5 years. And the companies are obligated to continue paying until the total of the $32.5 billion has been paid in full. So the obligation continues for as long as it takes for those funds to be paid. And the percentages are, as I've indicated, in each year in those 5-year increments.
Great, thank you. And just while we're on the payouts, how do governments intend to use this money, and will all of the payout go to healthcare costs?
Let me take that, Caroline. I mean, the answer to that question is yes. Our clients from the outset told us that the purpose of this litigation was to recover healthcare costs that have been increased as a result of smoking-related diseases that were caused by the wrongful conduct of the tobacco companies. And throughout, we have been instructed that the plan is to use those funds to improve the healthcare systems for all of their citizens. That includes not just cancer-related treatment, but also it includes other programs that the provinces deliver, such as smoking cessation programs. The fact is, this amount of money will make a significant change to the way our clients are able to deliver healthcare for the provinces.
Anyone else like to add on to that? Okay, great. Our next question comes to the number of claimants. Specifically, we're looking for a clarification on how many individual claimants there are in the Quebec class action versus how many there might be across the country. And additionally, could anyone else in Quebec subsequently make claims to the proceedings? I'm not sure if this is a Mike Peerless question or perhaps André, I'm not sure.
I'll actually just start it to put something in context and then pass it over to André. But just for clarification, as I mentioned, individual claimants are represented within the class actions, so would not separately vote on the plan. However, it's important to note that if the CCAA plans are approved and implemented, there is a separate claims process for individuals to prove their claims, and this will be overseen by the plan administrator, as André mentioned.
Thank you.
Maybe it makes sense for me to step in here, because that was a great background to this. But in kind of class actions like this, where personal injuries are involved, no one has necessarily had to identify themselves yet to anyone. So we don't really know how many claimants will come forward, personal claimants will come forward in these cases, and to what extent they can prove their claim. That was, for example, there are certain types of diseases that are very likely to have been caused by smoking. And if people can prove that they smoked for a long period of time and then got one of those diseases, then they're eligible to both make a claim and to be compensated. But we don't know individually in Quebec or across the country how many people will come forward and make a claim. They will do that separately. If and when the plan is approved, there will be a claims process that will be sent out. There'll be an extensive notice process that will tell people how to come forward and make a claim.
Thank you for that, Mike. And just to follow up a little bit, so this has been going on for 2 decades, these proceedings. Some people may have passed away in that intervening period. can their estates or their relatives still apply for the compensation that they would have gotten were they still alive? How does that get treated?
Yes, again, the plan provides for that. As you know, we represent the provinces and territories. So those are matters that are being handled by, for example, the Quebec Class Action Council and also the Representative Council for the Pan-Canadian claimants. But the plan actually recommends claims administration entity that would be responsible for receiving and facilitating the processing of those claims across the country.
Thank you, André. There are proponents who are party to these proceedings who suggest that this really won't have much of an impact, detrimental impact to the operating of tobacco companies. And effectively, this represents a business as usual scenario for these organizations. How do we comment on that? Maybe Mike?
Sure, Caroline, thank you. Look, this has been a long road, and there have been many successes along the way for the provinces and territories as they have worked to reduce and eventually eliminate smoking. During the time period that this litigation covers, the early part of the time period, the percentage of people who smoke daily was approximately 50%. We're now down to the point where it's just a little over 10%, and our hope is that it will continue to move down. I don't think we can at all take comfort in the fact that we've moved that far, that our clients want to certainly move further. But it has been steps along the way to some extent. We've raised the price, our clients have raised the price of cigarettes. There are bylaws that limit where smoking can occur. There are bans on certain kinds of advertising and product labeling. This addition to the healthcare system will provide the kind of support that can continue to support those initiatives that are based on reducing demand. And we think that you simply can't look at this resolution, it's not a settlement, this resolution, this plan as being anything other than a very significant step along the way to eliminating smoking completely someday.
Thank you, Mike. Our next question begins by noting that in Ontario alone, the total direct and indirect healthcare costs of smoking are estimated to be around $7 billion a year, according to Government Public Health Ontario. How close does the compensation here come to actually covering the costs of provinces of tobacco-related illnesses? André, this is probably best started by you.
Yes, well, of course, the context of the claim is to recover to the greatest extent possible the cost of the healthcare benefits that were attributable to smoking. And within the plan, you'll see the claims of the provinces that had been laid out. Measured against that, of course, is the reality of the CCAA and the plans that are of compromise and arrangement. So what this plan does, from our perspective, is hold the companies accountable. For the past 5 years, those funds have been withheld, and into the future, until the settlement's paid in full, the companies will continue to be monitored, and they will be and the requirements will be for them to continue to have to pay until the global amount is paid.
Thank you. Our next question likely goes to Preet. Will there be a consultation process by which class counsel will seek out objections from potential claimants or their representatives in representative individuals covered under the specific class action? So I guess that's back to process.
It's it's a little more of a question for Mike or me as class action lawyers, because the class action is in Quebec, and frankly, it's probably a little more of a question for class counsel in Quebec. Class actions that are resolved, and occasionally, because of some of the language that's been used, we've slipped into using the word settlement on occasion ourselves, and that's a mistake. This is not a settlement, it's a plan. But if we get to the point where something is being put forward to the Quebec court to resolve issues with respect to the class action there, then there will be a process to deal with that as well. Mike?
Yeah, I think it's, I think, as you said, it's more of a question for Quebec class counsel than for us, but I do think that this proceeding is different than a typical class action settlement, even in a place like in the context of the Quebec case. And that's because typically a class action settlement is made between the parties and is brought forward to a court for a fairness hearing. And the judge in that context needs to hear about something about why the settlement is fair and reasonable. In this case, after a 5-year mediation with the former Chief Justice of Ontario and the court-appointed monitors and counsel from around the country participating, it's, in a way, it's a little further down the road than most class actions are at this point. And by the time it gets to court, it will be up to Justice Morowitz largely to decide how to proceed on that. But by the time it gets to court, I'm not sure whether there will be an opportunity for individual smokers to come forward and make a submission. But Preet could probably actually just answer that question.
I think it will very much depend on the process that's adopted. I'm just not sure it's something, again, that we can answer right now.
Thank you so much to all of you. We have a question with respect to the application of the funding that provinces are anticipating. So can provinces apply some of the court-ordered funds directly to tobacco reduction activities? And is there anything that restricts them from doing so?
Provinces fund smoking cessation. That's something that they do as a matter of course. Certainly our clients do. And there is, fair to say that there's no restriction on that.
Thank you. We just have a follow-up on the question of how close does the compensation come, André. So question again is, how close does the compensation come to actually covering the province's healthcare costs? Does it cover a particular percentage or an annual healthcare cost claimed by the provinces? I guess really the question is, how does that get applied?
So again, the amounts are allocated to each province, and that schedule is set out in the plan.
Set out in the plan.
It's set out in the plan. So then, yeah, each province will be receiving the funds that has been allocated, and then that province would then designate funds accordingly for provision of healthcare benefits, if I'm understanding.
Thank you.
I think I might be able to help to be of some assistance though. I think the question is, for example, does the benefit going to an individual province cover 100% of their smoking related healthcare costs? And I think the answer to that is no, it doesn't. But what percentage it does cover would be difficult to say, because it would be very highly disputed what the healthcare costs would be. In other words, these companies' legal position is that this probably does come close to covering it. The province's legal position is it's not quite sufficient. But the reason the word compromise is built into this legislation is because that's normal in a legal dispute like this. And ultimately, as André laid out at the beginning, the companies have been paying a very large percentage of their revenue into court for the past 5+ years, and will continue to do that until this $32.5 billion is paid. They can only pay what they have. That's part of the compromise.
Thank you. Preet, we just have another touch base on timeline. So clarifying the period of time that claims will be paid out. Question here is both in Quebec and the rest of Canada. I think this goes again to timeline that you spoke of earlier.
Sorry, is this the timeline for the plan being approved and implemented, or?
Payouts for compensation.
So if the plan is approved by the court and then implemented, and there's a number of conditions precedent to that within the plan, then the payments can start. And I believe André would be best positioned to speak to those.
Sorry, would you repeat that question?
So we're having a clarification.
Okay.
Asking about the period in which people got sick or addicted. Oh, what years are being covered? So what does the proceedings, the period of time does it cover?
For individuals, for the provinces and territories.
Or individuals.
So there are different periods of time for the Quebec class action plaintiffs. It's the period of time that for which they were awarded compensation by the Quebec courts. So that's set out in their judgment, and their counsel will be able to elaborate on that. For the pan-Canadian claimants, we have the plan is laid out that they would have been diagnosed. Eligible claimants would have had to have been diagnosed with the compensable diseases within the 4 years prior to the filing of the prior to the CCAA filings, which were in 2019.
Thank you. Just with an eye on the clock, this might end up being our last question. And that being, why do governments get more of the money than individual claimants who actually have suffered the smoking-related diseases?
Let me start with that one. I mean, that is simply a function of the fact that for decades, the provinces have been paying the costs of treating smoking-related diseases for the benefit of individuals who have suffered. And it's also a function, I think, of how we evaluate legal claims and the value of those legal claims. That said, there are more than $6 billion being put aside for, according to the plan approved or suggested by the court-appointed mediator, for individuals. They will also be getting their money at the earliest stages. So it's hard to kind of compare apples and oranges. They are different kinds of claims. The individuals have very significant and serious claims and are being compensated very well for them. Although obviously we all wish that there was an endless supply of research. The provinces, of course, will continue to care for and treat all individuals who have smoking-related diseases and need care. And I want to make sure I say provinces and territories. That's a mistake on my part. Our clients include the territories for whom this is very important as well. So it's very difficult to compare the two groups who have different kinds of claims, but it is a question that you should ask the council who have been caring for the pan-Canadian claimants as well as the Quebec class action plaintiffs.
Thank you, Mike. And finally, is this a fair proposal?
Well, let me start, and we may all want to address that. I think Preet does. We need to remember how we got here. And the way we got here is after decades of litigation and an extremely knowledgeable, experienced mediator, former Chief Justice of the Ontario Court of Appeal, Warren Winkler, appointed by the Ontario court to be the mediator in these proceedings. And he has concluded that this is a way to move this matter forward to a conclusion. There is no question that these matters involve compromises at some point. Sometimes the perfect can be the enemy of the good, and that was recognized by Chief Justice Morowitz when he directed former Chief Justice Winkler to prepare this plan of compromise and arrangement, and that's a transition to Preet.
Thanks, Mike. Yes, what I was going to say is when Chief Justice Morowitz directed the mediator and monitors to develop these plans of arrangement and compromise, he specifically said no plan is perfect. And that is true of any plan of arrangement and compromise, because that's exactly what it is, a compromise. And so while we cannot, say this is perfect, the test for the court to approve it is whether or not it is fair and reasonable. And our clients will support the plan as proposed by the court-appointed mediator and monitors to try to bring these complex and lengthy proceedings to a resolution. And I will also note that it should not be lost on anyone that $32.5 billion is not business as usual.
And it is our view as well from the economic perspective that this plan is workable.
Very good, thank you. And one final question, just a clarification around the new foundation that will receive funding. Can the foundation invest in anti-tobacco campaigns and advocacy, or are their activities limited to research?
The foundation is independent, and it's being headed by healthcare specialist, Dr. Bell. The smoking cessation programs have been and will continue to be funded by the provinces and territories. Anything else that you'd like to add to that, Mike?
I think that's a good answer. Certainly, smoking cessation problems are important to our clients. They continue to fund them, and the money they will be receiving will enhance their ability to deliver on such programs, as well as to improve healthcare, which is the center of what they are interested in this litigation, and has been from the beginning.
Terrific. Thank you very much. Well, ladies and gentlemen, that concludes our discussion for today. Thank you very much for your time and participation. Thank you to our speakers, Mike, André, Preet, and Mike. We wish everyone a wonderful afternoon. And if anyone requires any follow-up information, background, or requires a discussion with one of our speakers, please feel free to email me as outlined on the advisory, and we'll be happy to help you as best we can. Have a wonderful day and a terrific weekend. Thank you so much.
Everybody keep my time.